Hello, Justice Robie.
Hi.
Hi, I'm delighted to be here with you in this beautiful courtroom. And I'm just going to get right to it and go back a few years just to get started with talking about your career. You started out, we're only going as far back as college, so UC Berkeley, English and journalism, master's degree, and then you ended up in Sacramento. And what brought you there?
Well, I came in Sacramento as a Ford Foundation legislative intern. And if I were to come today in that, you would call me an assembly fellow. The program has been going on all that time. And I came to Sacramento and I was assigned to the water committee. It was not my choice, but that's the way things went. And as a result, that's where my career went.
So you weren't interested in water particularly up until that point?
No, I had no particular interest at all. And I was assigned to the Assembly Water Committee, and the chair of the committee was Carly Porter, the author of the Burns-Porter Act that created the State Water Project, and a really nice man. And the committee didn't have any staff except me. And in those days, it was a part-time legislature. So I ended up working for the committee for 9 years, as I will explain. But anyway, so during the time that I was there, I got involved in water pollution and water quality because the Water Quality Subcommittee was assigned to Mr. Porter. And I learned, much to my surprise, that the Water Quality Act, which was then in effect, the Dickey Act, which had been passed in 1957, was designed to make it easier on polluters because they were mad at the health department who had been enforcing the law too strictly. And so we had a water pollution program with regional boards with polluters as members of the boards deciding what to do. And then we had a very weak state water board, state water quality board that included department heads from state government, and it was just a mess. And so my boss decided that we would do something about it. And I came up with this idea of combining the water quality board with the water rights board, which frankly didn't have enough to do. It was a 3-member board, and it was a full-time board headed by an attorney at the time. And so he said, well, you know, that's a little bit of a drastic change. We ought to trial balloon it. So I wrote a staff report to the committee and released it. So if it fell flat, then he wouldn't get blamed for it. So, and it was popular. People really liked it. We had legislative hearings, and as a result, it was enacted. And so in 1967, we created the State Water Resources Control Board, 5-member full-time board, and then it supervised the regional water quality control boards.
And did all that work have any influence on your decision to go to law school?
Well, it did. During the process of doing all this, I said to myself, you know, I'm a journalist, I need to have a career. So in 1963, I enrolled in law school in the evening and graduated in 1967, just at the same time that the water board was enacted by the legislature, unanimously, by the way. And but the one thing we had remaining was we had a terrible water quality law. We had a good administrative structure, but we needed a better law. So I met with, and my boss met with the executive officer of the water board, and we decided we'd set up what we called the study project. And it had 5 subcommittees headed by very prominent people. And we put all the interest groups together, and we took the entire law and broke it apart and put it in each of these groups, and then came up with a brand new law that was quite a bit tougher than the old law. And it was sent to the water board. They toughened it a little bit more, and then it passed the legislature in 1969. So we then ended up with a very good water quality board and a good legislative program of regulation of water quality.
And you were on the board at some point in
that
period.
This is sort of funny because while the Porter-Cologne Act was going through the legislature in April of 1969, the chair of the then water board, the attorney member, retired. And so the executive officer of the board, I think he said, you know, I need an ally on this board. So he talked to Governor Reagan, and they convinced the governor to appoint me as the attorney member of the board. So barely 2 years out of law school, I became the attorney member of the water board.
And vice chair at some point, right?
I was the vice chair for a while, yeah. So anyway, I ended up being on the water board, which was sort of fun because I had something to do with creating it. And so that was very nice.
And from that board, you spent 8 years as the director of the California Department of Water Resources. And can you tell us what it was like working with Governor Brown? And,
well, if I could just first tell you something about the water board,
yes.
Because I have a couple stories to tell about the water board, if I could do that. First of all, we did a number of decisions that were really pretty important, and we had a really good board. We did the lower flows, minimum flows on the lower American River through Sacramento here, which required the East Bay Municipal Utility District to take their water from the Folsom South Canal out of the Sacramento River, which was it took 30 years in litigation before it was finally resolved, but the water board did that. We also created the first Delta water quality standards applicable to the water projects during those years that I was there. And so those were major accomplishments, and we enforced the water Porter-Cologne Act strictly. And San Francisco was a terrible polluter. They were dumping raw sewage in the bays hundreds of days a year. And so one of the great features of the new Porter-Cologne Act is that you could have a building ban. The board could impose a ban on new construction in any community that was a serious polluter. And so we imposed a building ban on the city of San Francisco. And Mayor Alioto became furious and came to Sacramento and personally appeared before the board to protest. And I'm proud of the fact that he called me a sanctimonious demagogue. Well, that's the water board. Yeah. But anyway, when I went to DWR, I was honored by Governor Brown to be selected to head the department that runs the State Water Project, and it had been historically a development organization, and here I was, the guy who came from the environmental board. But that was my goal at the department, was to make it more environmentally oriented. I brought along Jerry Merrill, who is with the Environmental Defense Fund as a deputy director, and I appointed a woman from the Sierra Club as the deputy director. And Governor Brown was very responsive to that approach. And although we did pursue the peripheral canal during that period of time, it was loaded with environmental goodies. And in fact, we had lost the support of several Southern California legislators when the peripheral canal bill was going through, because they thought it was too environmental. And so that was sort of a badge of honor. But Governor Brown was very smart and was very much involved in everything we did.
How was he to work for in that period?
He was great. We went through the most serious drought in California history at the time, 1977. And during that period, we had to go all around the state. We went back east, preaching water conservation. And we had created the department, the Office of Water Conservation in the department. And I can remember the governor going to Denver and taking out one of the toilet dams, those little things you put in the toilet tank to minimize the flow, held it up and got on page 1 of the New York Times because he had an active program, and he was very, very supportive of what we were doing.
You mentioned, we spoke a little earlier about some famous jurist who worked with you in Sacramento or was an extern or intern with you that might be interesting to describe.
Well, when I became a legislative intern in 1960, there were 10 of us, and one of the members of my class was Rose Bird, who later became Chief Justice. And she hadn't gone to law school either by then. So both she and I were talked into going to law school, having worked for the legislature. She then enrolled at Stanford and went on a course to not only become Chief Justice, but before that, she was the Secretary of Agriculture in our Brown administration.
Thank you. I'll turn it over to Rick.
I'd like to hear a little bit more from you about your tenure at both the Water Board and as Director of the Department of Water Resources. In addition to the flow standards that you mentioned that you worked on and got enacted at the Water Board, what were some of the other highlights of your tenure as Vice Chair of the State Water Resources Control Board?
Well, I think that we had a constant battle with the federal government. In 1978, we finally won with California versus the U.S. because the Bureau of Reclamation simply didn't comply with state laws. And during the drought, for example, one of the things that I did as Director of Water Resources was I imposed the standards that we had created at the Water Board on the feds, and the state water contractors had to dedicate water that they would otherwise have used to make up for what the federal government didn't do. So one of the things that we struggled with during the time that we were at the Water Board was trying to get the federal government to comply with state law. And I might add that with regard to the Federal Water Pollution Control Act of 1972, which is now the Clean Water Act, we had a good relationship at the Water Board with the staff in Washington who were working with Senator Muskie on passage of both the Clean Air Act and the Clean Water Act. But we were offered an opportunity to have meetings with the staff, and we got two main features in the federal act which supplemented our California law. Number one, the federal law includes a conflict of interest provision which knocked out direct polluters from our California boards. And we did that sort of on the slide, but it was really terribly important. And secondly, we got the federal law to have a provision that as to the water quality at least, that the federal government's facilities had to comply with state law. And we were having, at the time, a major battle with the Navy over boat pollution, ship pollution in, for example, San Diego Harbor. So some of the things we did were working behind the scenes with the federal legislation, and we, of course, were the first state which was approved by the federal government to administer the new Clean Water Act once it was passed. And we were very proud of the fact that we were the first state to qualify.
And then moving on to your tenure at the Department of Water Resources, I'd like to hear a little bit more about your first days and weeks on the running the department, because I dare say that it was the greenest management team in the Department of Water Resources before or since. And did you encounter a fair amount of institutional and bureaucratic pushback from the department that you inherited?
You must have listened to me before, but you know what? When I was appointed by the governor on like Friday and I was supposed to show up at the department on Monday, I told my wife I have no idea what I'm doing. And so I did know, however, a wonderful engineer from DWR, Robin Reynolds, who I had met before because I'd worked with him both when I was working for the legislature and at the Water Board. And I called up Robin and I said to him, Robin, would you come to the department Monday morning and sit next to me and tell me what to do? And he did. And he remained a deputy director for 4 years, the first 4 years of the administration. And yes, I was a lawyer. And you know, lawyers, I hate to say this, but we're not trained to be administrators. I mean, we end up in a lot of administrative jobs over the years because we have other skills. But it really took a little effort, and I sent all my staff, including me, to management classes. So that's what I did, but it was sort of a square peg in a round hole because the water industry people wanted me to save money. They didn't want me to spend money on water conservation. They didn't, and so it was a constant struggle with the water contractors, for example, who were constantly auditing the department, and they were after me because we wanted to do some things that were more progressive, and they thought were sort of outside the agenda. Of course, over the years now, with the environmental awareness that we have now, they accept all this stuff. But in 1975, it was new to them, and they pushed back.
So talk a little bit more about your career highlights and perhaps lowlights as director of the Department of Water Resources. I want to return a little bit in a moment to the peripheral canal battle, which is probably the most contentious and well-publicized aspect of your tenure as DWR director. But before we get to that, what other things are you particularly proud of from your tenure as director?
Well, I was very proud of some of the energy things we did. DWR is one of the largest energy producers and users in the state of California. And we had been strangled by PG&E because they wouldn't let us use their transmission lines. And so with some clever attorney general deputies working for us, we sued the PG&E, and on the last day I was director, we got a judgment against them to have DWR use their power lines to transmit our power if we wanted to send it outside our service area. that was a major victory. Now today, as a result of deregulation, power lines are a public utility, but at that time we had to sue to get it. And also, I sold all of the power at Oroville to Southern California Edison for a better price than PG&E would give us. And as a result, DWR really did well in power. We also expanded our hydroelectric capabilities. So that was one of the things I was most proud of, is our aggressive activities in energy.
Well, tell us a little bit about the ongoing saga and battle over the Sacramento-San Joaquin Delta, and you and the governor staked a great deal of your time and prestige in an effort to resolve that Gordian knot of water politics and water policy. Could you take us through that
Sure.
with the benefit of now 40 years of hindsight?
Sure. Well, I knew the Peripheral Canal didn't have a good reputation when I became director, so I created a Delta Alternatives Task Force, and I basically told the people in charge, come up with an alternative, please don't come up with a Peripheral Canal. And they spent about a year or so, and they came back to me and they said, Director, we can't come up with anything else. It really is the best solution. And as a result, the governor agreed, and we went ahead, because we really did a thorough study, and it was certainly not the most politically wonderful way to go, but it was the only way to go, so we did it. And it was my decision, the governor agreed that we should try, that in order to give it validity, we should get it through the legislature. I mean, everybody had told me that we could build it without legislative approval because of the Burns-Porter Act. But we said, no, we want to get it endorsed by the legislature. And as a result, it passed the legislature and was signed into law by the governor. And that became the problem, actually, because we struggled for a couple of years, actually, went through arduous legislative hearings. I spent many, many hours before legislative committees with this bill. And as I mentioned earlier, a couple of important people, like later Governor Duke Majan, voted against it because he thought it was too environmental. Because we had tied to it the adoption of federal wild rivers status for our state wild rivers, and which is still there. And as a result, we got through the legislature, but unfortunately, people from the Delta got a referendum, and the voters ended up turning it down. I felt terrible about it, but I think we did it the right way. I think we had public support for it in the legislature, but the voters, particularly in Southern California, who had the most to gain from the project, did not vote in sufficient numbers. And as a result, the Delta has gone downhill ever since. And the fisheries are even in much worse condition than they were then. And we're still fighting over it.
At the end of your 8-year tenure as DWR director in Governor Brown's first 2 terms, you became a jurist. Talk a little bit about that career change, what motivated you, and to move from the world of politics and public policy to the judicial branch of state government.
Well, I had a really busy time in the executive branch, as you know. I mean, spending 6.5 years at the Water Board and 8 years at the department was a long time. And I think that most attorneys will say the ultimate thing for an attorney is to be a judge. I mean, it's sort of the crowning place to be. And so Governor Brown appointed me to the municipal court in the last days of the administration. And I really liked being a judge, and I still like being a judge. I spent 19 years on the trial court, and I've almost spent 19 years at the appellate court. So I found them both really rewarding, and during the time I was on the trial court, it turned out being the presiding judge for a couple years, but also I did law and motion for 6 years, and I did writs for 6 years. So I got a lot of really interesting civil cases.
It occurs to me that you're probably the only California lawyer and perhaps the only California policymaker who, during your distinguished career, has served in all 3 branches of California state government. Any comments or reflections on that rather unique status?
Well, I was a nonpartisan guy. I mean, the legislature was dealt with water. We had a committee in the Assembly of evenly divided between North and South and evenly divided between Republicans and Democrats. Most people don't realize it, but I was appointed twice by Governor Reagan to the Water Board. And I have to say a word about Governor Reagan, because when he was governor, he was much more environmental and much more easygoing with his staff. He did not have I was horrified when he appointed his Secretary of the Interior, Mr. Watt, because it was so unlike his reactions to the activities in California. So I was with the Reagan administration, and I was actually appointed by Governor Brown. And then in 1986, I was elected to the Superior Court. And before I was elected in the June primary, and Governor Duke Majan appointed me early so I could serve beginning in June, because I was filling a vacancy. So I really got appointed by governors from all over the place as well.
You're widely recognized as the California jurist with the deepest and broadest expertise when it comes to water law. Can you share with us some of your water law cases over your judicial career that you believe are and were most consequential, and those that were most enjoyable for you to decide?
Well, you know, I have to make it clear that both at the trial court and at the Court of Appeal, we don't assign cases by specific expertise of judges. They're randomly assigned. So I got some water cases, but I didn't get them, I got them because I got them. I mean, it's just the way it worked out. But my biggest case, and the one that, I had two big cases that I'm sort of proud of. One of them is, the first one was the Delta cases, the Delta decisions, which were in 2008, which dealt with the Water Board's eventual regulation of the Delta and water rights and water quality. That was a couple hundred-page opinion, and it was a lot of effort between my colleagues and I to get it done. The other one was the Quantification Settlement Agreement, which was the big settlement on the Colorado River that ended up with 200,000 acre-feet of water being transferred from the Imperial Irrigation District to the greater MWD area. And the Quantification Settlement Agreement was vigorously opposed by the Imperial Irrigation District, which actually had been a signatory to it. So it was a very unusual situation where they signed this agreement and then disavowed it and litigated it very forcefully. And we had two decisions in that case. The first one dealt with environmental issues, and then it went back to the trial court, and then it came up again, and then just before my 150-page opinion came out, they settled the case. So the district settled the quantification agreement. So that was a really significant thing to get the Colorado River problem resolved. And I think that the water law that we established in the Delta cases was very useful as people went ahead in future cases. But you know, a lot of good water cases are coming out of the first district and various other districts, which have expertise as well.
One of the your lesser known but very significant roles, along with your deciding cases in the trial courts and now in the appellate court during your 37-year career, is that from time to time you've been called upon and appointed, I believe, by the Judicial Council to serve as a special master to help mediate and resolve cases outside of the traditional judicial process. Could you talk a little bit about that? And,
well, I offered myself up as an appellate judge to help mediate cases, and I did work at great length with Judge Komar on the Antelope Valley groundwater adjudication case, which lasted almost forever, as most water law cases, 20 years. But while I was at the Court of Appeal, unfortunately we didn't completely solve it, but we got most of the main issues resolved through mediation while I was serving on the Court of Appeal. So that's a role that I really enjoyed doing. I enjoyed settling cases and mediating, and because I was not involved in that case, it was a case out of Los Angeles, but it was tried by a judge from Santa Clara County. I could be completely useful as a mediator because I'd never see the case again, and so I found it really fun.
In addition to your day jobs with the California Legislature, then in the executive branch of state government with the Water Board and the department, and as I say, for the last nearly 4 decades on the bench, you've somehow found the time to be an educator as well, to help train and educate generations of both lawyers and judges. I'd like to focus initially on the opportunity you had that I assume was quite rewarding to go back and serve as a faculty member at this very same law school that you attended as a student.
Indeed it was. I graduated in 1967. In 1970, Dean Shaber, who said, you know, environmental law is a coming field, we ought to be teaching it. Here, teach it. And I said, oh, okay. And at the time, in 1970, we didn't have a case book. We assembled cases from going on. We couldn't go online. We just bought copies of the slip of opinions and handed them out. And I taught for 43 years at McGeorge. And in addition to teaching environmental law all the time, I taught water law for a while. But they also had some very distinguished water law professors like Frank Trelease. And so they didn't need me. But I also taught law of the sea for a while, which was sort of fascinating. But teaching has been important, and you know, since I've been at the Court of Appeal, I've had at least 2 externs a year, and sometimes 3 or 4 in my office, working with me directly. And I consider that an important function of being a judge, is spreading the word to young lawyers, the experience of working with an appellate court, knowing how the courts work, and learning the skills of writing that you can obtain by working at a court.
Aside from your teaching at McGeorge School of Law, you've done a lot of training of judges and attorneys in other capacities as well. And in that regard, and continuing my focus in these questions on water law and policy, you helped organize, you created an organization of judicial education, I believe, along with then Chief Justice of the Colorado Supreme Court, Greg Hobbs, a judicial training program you titled Dividing the Waters. Could you talk about that?
Actually, the inventor of that was John Thorson, who was the Arizona Supreme Court's water master, a stream adjudicator. But I did join the group after a few years, along with Justice Hobbs, and it's called Dividing the Waters. It's been around for a number of years, and it's now affiliated with the National Judicial College. And we can have, every 2 years, we have a national conference of water lawyers, water judges. It's a judge organization. And we now have on our panel Supreme Court justices, in addition to Colorado from Washington and New Mexico, plus trial judges from other areas. And so that's an important educational activity too. And as you know, I am part of the teaching panel for the CEQA classes that the Judicial Council of California offers to trial, appellate judges and their staffs, because we have CEQA judges in California, and we are obligated to train them. And Susan is one of the members of our panel.
And Professor Frank
and
sometimes
and
too.
you have been on occasion as well.
And can you explain anything more about, I mean, your participation in those programs make them work. Can you describe any more about why you think this is important?
Well, you know, the main operating method of CJUR is to have judges teach judges. That's part of the ethics of it. And we asked for an exception. We said, you know, judges can teach CEQA, but the people who really know CEQA best and can give judges a real flavor for what's going on are the lawyers there's a bar, a CEQA bar, they specialize in this. So as a result, 3 lawyers and 1 judge teach this class. And Susan is a petitioner's lawyer, and we have other lawyers representing different points of view, developers, and so forth. And so we've been teaching this for 20 or more years now. Yep. And the other great feature about it is that it not only is offered to judges and justices, but to their staffs. And it's very unusual for staff education and judge education to be done together. They're always done separately. And I think sometimes judges are afraid they'll say something funny or stupid if their staff are there. But in CEQA, everybody's working together.
And they're 2-day classes, right?
And they're 2-day classes, and I think And you, Susan, are the one who prepares the syllabus for us, and so everybody who goes to the class gets a really great summary of CEQA. So I think once we get back in person again, I'm hoping to see a lot more judges who have not been able to do this during this pandemic time.
Well, speaking of CEQA, beyond, I mean, water issues are a huge part of CEQA, but obviously it's a much broader field. In terms of some of your your decisions, Your Honor, one of the first ones that perhaps you could speak to is Communities for a Better Environment when you were not yet an appellate justice.
I can't imagine how important Citizens for a Better Environment was, but in the late 1990s, I guess it was, because I was still at the trial court,
2000
Governor
decision.
Wilson made the only attempt that I know of that's been made in the 50 years of CEQA to get rid of the fair argument rule, which of course is a very important part of CEQA. And so he proposed regulations to the guidelines that would basically eliminate the fair argument rule. And it came to me as a writ judge in the Sacramento Superior Court. And I, with my staff, had reviewed it and determined that it violated the law. The statute provides for the fair argument, and the regulations were not consistent with the statute, so I ruled them invalid. And they came to this court, the 3rd District Court of Appeal, and they affirmed my decision, and it became a big deal. And I must confess, at the time I did it, I was a trial judge, and I didn't think that it was that important, but it turned out to be.
Indeed. And another recent case you were involved in, Your Honor, involves a standard of review, the Sierra Club versus County of Fresno. Can you tell us a little bit about that?
Well, the only thing I can tell you is that the Supreme Court staff called me and asked me if I would sit pro tem because there was a vacancy on the court. I said yes, I would. And they said, well, we have 2 cases. We have one from the 3rd District and one from the 5th District. Which would you like? They didn't tell me what their names were. They just said we have 2 of them. And I thought, I said, I don't think I should take a 3rd District one because I'll maybe dealing with one of my colleagues. I'll just take the 5th District one, and that turned out to be Sierra Club versus County of Fresno. So when I say that cases are assigned randomly, that really is an example.
Well, how do you see the future of environmental law, for just shifting gears here a bit, for law students and young lawyers that are going to be watching this chat? Do you have any advice on how to prepare for a career in the environmental law, on whichever focus?
I think environmental law is a terribly important area of the law, and it's not going to be any less important in the future. When I graduated from high school, I ended up reciting we had a ritual that the speakers at graduation did, and there was a message that came forth, and then one of the things that was said was, "At this too shall pass away." It's a very important thing to remember, and particularly if you're young. If times look like they're not great right this moment, stick with it, stay the course, and this too will pass away. Right now we're going through a crisis for environmental law because the current administration of Washington is trying to back off of a lot of really important things that have been established over the years with NEPA and air quality and water quality. But I think if we just, the world around us is going through a climate change that is undeniable. And even if you do deny it, it's not deniable. And so if you just be patient, folks, this is an area of the law that is very important, and it's going to stay important. And there's still going to be opportunities for jobs. And I always like to tell students, there's opportunities working for Exxon just like there is for the Sierra Club. In fact, there are probably more jobs in industry than there are in environmental groups. So it's a great area to practice, and stick with it.
What about your participation as, I forget what you said it was called, an internship or an externship? Do you recommend that as a way to find out about environmental law for young people?
I do. I think people should, there are all sorts of organizations that are offering an opportunity for students to participate and learn, and I think that's really, and in my chambers, what I like about it is that I give them regular opinions to draft. I take them right off of our inventory, And instead of giving it to one of my staff attorneys, I give it to the externs. And I'm very proud of the fact that in the last 3 months, 3 of my externs have written opinions that have been published in the official reports. And that's pretty amazing, because I only publish about 8 or 10 cases a year. And so the externs are getting really serious stuff, and I think they get a really good education from not only me, but my staff particularly, because they really, and in fact, both of my 2 staff attorneys were externs in my chambers 10 years ago. So they're not,
Oh, wow.
They were trained by me, and now they're back working for me.
Do you have any thoughts to share? What, in your view, makes an environmental appeal compelling, or any advice for practitioners before the court to make their case compelling in a special sense with environmental issues?
Well, you know, the only advice the advice I give to all lawyers is state the facts fairly in your papers, because so often lawyers just can't get away from the virtues of their own story and have to tell it biased, and I frankly tell my people who ask, I sometimes read the respondent's brief first, just because so many appellants don't accurately present the facts. Come forward with the facts.
They're advocating too early, aren't they? Yeah.
Yeah, I think show the places where there is a problem, and then show why it's not really a problem. I mean, don't hide the ball, and come forth and be straightforward about what you say, no matter what you say. And this is not just environmental cases, this is criminal cases or any kind of case. Be straightforward with the court, because we have lots of time to figure it out, and we will figure it out, even if you don't help us. And so I think that's the best thing that I can advise somebody to do.
Is there any part of your career or work or stories that we didn't ask you that you might want to tell us a bit more about, Your Honor?
Well, the only thing that, I've done a lot of different things, but about 10 years ago, the Chief Justice appointed me as the chair of the Supreme Court Committee on Judicial Ethics Opinions. And we've been operating now with 12 judges, and we issue ethics opinions for judges. And I think this is a really important function, and there is a committee of the Supreme Court that adopts and modifies, with the court's approval, the canons of judicial ethics. But we're called upon all the time to issue opinions on what judges can and can't do, because it's very important that judges understand ethical obligations, because if they don't understand them and they violate their requirements of the canons, they can be disciplined or even removed from office. And so that's an important function, and it's one that occupies a lot of my time now. But because I'm an appellate justice and my time frame is different than trial judges that have to be in trial all day, I have the opportunity, along with Doug Miller, a justice from the 4th District in Riverside, of spending time to leading this activity. So I consider that an important function of my job.
Any other questions from you, Rick? You didn't.
I guess one thing I would be interested in hearing about we haven't touched on. I don't know if it's a function of geography or your deep expertise, but you're from time to time called upon by the Chief Justice and the Judicial Council to go across the street and testify on behalf of the judiciary on key points, whether it's the California Environmental Quality Act or something else. Talk a little bit about that.
Well, I think the reason I get to do it is because I'm across the street from the Capitol, and I can see the Capitol from my office. And so when they want somebody to run over and make a presentation, that's what I do. But I have worked with them on, I have worked with legislators on the Groundwater Management Act, SGMA. I have worked with them on CEQA, and I have made informational presentations to the environmental committees of the legislature. And it's also, I suppose, because I spent so much time dealing with the legislature when I worked for the state, when I worked as director. I spent so much time, I don't mind, and I actually sort of enjoy going before legislative committees. And so it is some function that I am occasionally called upon to do, and I'm happy to do it.
And I dare say that you are atypical when it comes to most judges, and especially appellate jurists, from whom you don't hear much outside of their official role. You, I think, distinguish yourself not only as a result of your speaking, educational outreach opportunities, and you're a prominent and frequent speaker at conferences. You don't seem quite as reticent as many of your judicial colleagues to engage and interact with the legal community and legislators on a semi-regular basis.
Well, you know, I think that the canons of judicial ethics encourage civic involvement and judges to be in their communities. It sets forth some standards that guide you so you don't get off base, but being with your community is very important. This court, under Justice Scotland, for the last 20 years, has regularly gone to high schools throughout our district. We have 23 counties in the 3rd Appellate District, and we have gone to counties, high schools throughout this part of Northern California, and conducted oral argument in the presence of the students and the lawyers in the communities we go to. Meet with the students ahead of time and tell them about the cases and the issues that are being involved, and then afterwards they meet with the justices, meet with them and answer their questions. And even the Supreme Court does this now. So I think this is an important function, not only for the court as a court, but it's an important function for judges as judges. And there are so many things we can do to let people know that we're real live people. We're not just, you know. And I think it's important. And I think you'll find that there are a lot of judges doing this. It's not just me. Judges all over the state are regularly relating to their community and conducting teen courts and doing so many great things. And I think the Chief Justice has been very supportive of public outreach and participation in public activities of this type. And her citizenship and initiatives are really important. And we have a group in Sacramento, Operation Protect and Defend, where we go to high school classes, along a judge and a lawyer go to a high school class in our town and visit with the seniors and talk about an issue each year. We were talking about voting rights this year. We got it all done before the pandemic closed us down, but so we're doing a lot of that, and I think that's important. And most of my colleagues enjoy it very much.
Well, Justice Robie, thank you so much for a most enjoyable and enlightening conversation with you today.
Yes, thank you, Your Honor, and congratulations
again. Well, thank you so much.